Do you have constitutional questions? Get constitutional answers. We'll be answering your constitutional questions live, so get ready to call in now. Are you a prosecutor, law enforcement officer, or local government employee? Want to make sure you are executing the laws in a constitutional manner? Are you a city council member, township board member, or state legislator? Want to ensure the laws you pass are constitutional? Perhaps you're a citizen who wants to know the proper limits on government and the protections for your God-given liberties. Regardless of your role, call me, Constitutional Attorney Catherine Henry, with your constitutional questions during our live call-in show now at the phone number listed on the screen. And remember, together we can restore freedom.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Hello, everyone. I guess I'm not quite ready yet. I didn't turn my lighting on, so I will be right back. Okay, not sure that lighting's actually better, but we'll blame it on the Liberty Warrior if the lighting is worse than it was. So with that being said, I am not sure why our chat box isn't showing today, so that's great. Let's see if it shows on any of the other screens. No! That's awesome. Okay, well, I guess we'll do without the chat box today. Yes, I didn't have any of my stuff on. I didn't have the lighting on. I didn't have the sound on. I was just so ready to talk to you guys today that I forgot all the steps necessary to get us rolling. But welcome. I'm Constitutional Attorney Catherine Henry. This is Restore Freedom Weekly, and this is where I take your calls live about legal and constitutional questions. And keep in mind, I am only licensed in a handful of jurisdictions, including the United States Supreme Court. But if there's a question you ask that I just don't know, I'm not going to pretend I know. I'm going to tell you I don't know. So some people get mad about that and they claim I'm being difficult. But hey, I'm not going to pretend and then steer you in the wrong direction. So there we go. All right. I'm going to just look through the chat here to see if I missed any questions while we were getting rolling. Okay, well, we will still, Black Quiver, we will still be on in 10 to 15 minutes, so you should be fine. Let's see. Okay, better audio than usual. Well, that's good, because I didn't do anything different, so let's see. And I see the chat box is showing now. Thank you, Lori, for pointing that out, because, yep, it's pointing out while it's on the screen, so that's good. All right, so, okay. No, I can see the chat. Different times we've had different issues with chat not showing up. Sometimes, like when I used Rumble Live, which I loved because then I could multi-stream to Rumble and to YouTube. That was great. But anyway, when I used that, I wasn't able to see the chat. It wasn't coming in, even the Rumble chat. And I'm like, well, what's the point of that? So I had to open a different chat box in the background and go back and forth and all that. These last, 6 months or so that I've just been using OBS, I can actually see the YouTube chat. I can't multi-stream this way. At least I haven't figured out how to do that yet. But anyway, I can see the chat. It just wasn't showing up on the screen. So, we were going to have to make do, but we could still do the show if I could still see the questions that way. So with that being said, please take a look at Lori's latest comment in the chat that says, oh, and I realize it's only showing me, okay, There we go. I had to switch it to a setting on my end so I could see everybody's questions. But she says, if you have questions to help me see them better, please type them like this, where you have a question in all capital letters, and then you put your question itself behind that with normal capitalization. I can see the word question, and it's easier for me to go, oh, gotcha. So please go ahead and do that when you have questions today. And okay, let's see. Update. Ooh, that's a good way to do that too. I like that. So if you have been a caller or asked questions before and you're just providing an update, I love the way that John Q. Public just did that, because it was super easy for me to see in capital letters. He put update. He's not asking a question. It's just an update, but it was super easy for me to see, catch my attention. So please do it that way if you are someone who's just giving us an update. The judge denied the court-appointed public defender motions to dismiss and the motions to suppress in my case without me present in court. Oh, sounds like there's a lot behind that. So anyway, yes. And I'm not sure what Bootlicker is getting to here by showing the raise your hand emoji, because it's a little, I don't know, it's hard for me to just be able to answer a question like that. If you want to symbolically raise your hand, that would be dialing the phone number. So for that reason, I will switch the screens and give you that call-in phone number for today, 616-303-0093, 616-303-0093. Every so often, we do have people calling that number when we're not on live, and I don't answer that phone any other time other than when we're live on the air like we are right now. My main office phone number is a totally separate phone number, so just keep that in mind. Oh, gotcha, Bootlicker. Got it. See that? I said only part of the name, so. Yes, and John Q. Public's update was about his Second Amendment case, but the whole statement about without you being present in court makes me think that there was, there's always something else going on more to the story, and as to why and what was going on and were you told about it, were you kept out of the courtroom, and whatever. There's a lot of other questions that I would have, of course, as a curious person and as an attorney, but okay, so let's see. Okay. So go ahead and give me a call with any of your legal or constitutional questions. In the meantime, I'm going to go ahead and give you guys some updates. Usually this is the best way to get people calling in, right? Is when I try to give you guys an update, and then I have to stop with the update to answer the question. So there is a question. Do I do workman's comp? I do not do workman's comp. That's about one of the few things that I have not done much of anything with. I think I was involved in some mediation cases regarding some workman's comp years ago, but Blue Line Transparency has a question. Overnight Reluctant Prophet has notified us. No. Okay, I'm gonna phone a friend. Give me a second, guys. I am going to literally not call someone. I'm going to text someone about this question. Okay, so no offense to those that are providing the information. I don't know who Overnight Reluctant Prophet is, so I'm not sure about the veracity of statements coming from that individual. But I I just sent a message to someone who's a witness in the Lane Myers case. So hopefully we get a confirmation if that is actually correct. So anyway, sorry, I was blown away by the first part of the question. I will finish reading the question. Supposedly, at this point, Lane Myers has pled guilty. Can he still appeal the constitutionality of the indictments after the plea? Will the Court of Appeals do a de novo review or just review the denial of the motions to dismiss? Oh, you know, I'm going to be honest here on this one. This is something that I have actually done videos on before, but it's one of those things I just don't have at the forefront of my mind. So if you have questions about the kinds of things that you can appeal and what kinds of things you have to preserve and how you can preserve those, I go into detail in a series of, I want to say they're like 10-minute videos, 15-minute videos, specifically about pretrial motions, post-trial motions, things to consider in appeal. I've done whole like hour-long videos on appeals and things like that. And I know I go over this material. I apologize, I just don't have it memorized. So I don't know, when you make a guilty plea, can you still challenge the constitutionality? You give up a lot of rights by pleading guilty. And typically with a guilty plea, they tell you exactly what you're giving up. In fact, I wonder if I have, I wish I would have known this question was coming. I could have tried to pull up some documents back from when I was a public defender and my clients would do a guilty plea. There was a form that they would have to fill out, and then they would have to say it during their allocution where they are basically confirming and acknowledging the rights that they have and the rights that they are giving up by entering a guilty plea. And I don't remember there being much in there about, I mean, in theory, constitutional issues are something that, here's one that you can always challenge. Subject matter jurisdiction. If there's a way for him, if he did truly plead guilty, if there's a way for him to challenge subject matter jurisdiction, then that would be the way to go. Based on my recollection, it's been, what was it, 3 months ago maybe, that this is a public service and I were going to, he first sent me over the documents from Lane's case, and I read through them. And so it's been a while, but I want to say based on what I read, there would be a subject matter jurisdiction issue that he could raise. So that would be something that he could bring up on appeal even after he pled guilty. But otherwise, it does limit. It does limit. Okay, so Lane Myers is absolutely being railroaded. Oh, 100% he's being railroaded. Okay, Liberty Lisa asks, do you know real estate law or anything even basic about it? I know quite a bit about real estate law, but it just depends on what you're talking about and what jurisdiction, because real estate law is, it varies greatly depending on the jurisdiction. For example, Louisiana, totally different ballpark. I wouldn't even pretend to know anything about how real estate law functions in Louisiana because of the way that their laws are just, it's a different structure completely. But if you tell me what jurisdiction and what the general question is, I can go ahead and give it a shot. So, oops, let's see here. In Michigan, if you take a plea deal, then you cannot appeal. John Q. Public, I don't think that's 100% accurate, because you can always raise subject matter jurisdiction. You can always raise it. If the court does not have subject matter jurisdiction, if they did not have subject matter jurisdiction in order to accept a guilty plea, if there was no subject matter jurisdiction on the subject which you pled guilty, then that has to be thrown out. You know, if you have a bankruptcy court trying to enter a divorce judgment, there is no subject matter jurisdiction. That could not stand. If you have a criminal plea in a bankruptcy court, not going to stand. There's no jurisdiction there. If you have a probate court taking a felony guilty plea, not going to stand. It's not the right jurisdiction. So, anyway, it does drastically limit your ability to appeal when you take a guilty plea. But let's see. Okay, so Lisa's question is in Washington State. Okay, I have very limited information about the law in Washington State, but I could still give it a try because it's a lot more similar to the laws of the state of Michigan, Minnesota, Florida, etc., than it is Louisiana. And sentencing is July 1st. Okay. Okay, so Liberty Lisa, if you want to go ahead and tell me what your question is, I can go ahead and try to answer that. I'm still waiting for confirmation about Lane Myers. So I realize that somebody out there is posting about it, but I just wanted to go ahead and get that. Okay, so let's see. John Q. Public, I was just told that by the court-appointed public defender, county prosecutor, and judge. It wasn't coming from me, ma'am. Oh, regardless of who it's coming from, I mean that. Let me just say it this way. Would it surprise me if a prosecutor, a public defender, and a judge all got something wrong? No, it would not surprise me. But I understand that's why you said that. And in general, you lose a lot of the rights to appeal. A lot of the procedural things that you might otherwise raise, you're throwing out the window when you take a guilty plea. But there are aspects that you can challenge. So, okay, so Liberty Lisa's question. Our neighbors built a modular home too close to our property. Is there anything we can do now? How close is too close? We have 5 acres and they do as well. Well, again, the question about how close, what do you mean it's too close to your property? So if you have 5 acres, I'm making some guesses here, but I'm guessing there's a lot less zoning ordinances about how close to a property line you can build a home or a garage or those kinds of things. There still might be some on the books, but it's just a lot less likely than if you're in city limits somewhere. And so the first thing you want to do is really look to your local zoning ordinances about what they say. Because if they say nothing, if they are silent on the issue of how close that you can put a home or whatever to your property line, think about it from their perspective. If they are on their property, even if they build right up to the property line, if they are on their property, that's their property. They have the right to use their property as they see fit. The only issue, practically speaking, that you encounter then is if there is some sort of state or local, it's most likely local legislation, which usually would be in the form of a zoning ordinance, that would preclude you from being able to have property within a certain distance from the property line. Hello, this is Catherine.
Hello, Catherine. Are you live on?
I am live. You are live with me.
Okay. I can't even hear myself, but I had a question. You know, when you get a citation, well, and it says to pay $280, but it's a parking, supposedly it's a parking ticket, but it was never that. And you decide to fight the citation, does it turn out to be a misdemeanor and a petty offense?
Well, first of all, what jurisdiction are you calling from?
I'm calling from California.
California. Okay. Well, over in California, they don't know how to spell the Constitution, let alone follow it. So that's going to be our first problem. But secondly, I don't know much about the procedural nuances of California law. So it could be that there is a system set up where if you have some sort of, generally a parking citation can't be turned into a misdemeanor, even a petty misdemeanor, generally speaking. But sometimes you have, more like a moving violation that could be just a traffic offense, which is generally a civil citation. But sometimes if you want to challenge it and if you then lose, things can be escalated to a petty misdemeanor or a regular misdemeanor. It just depends on the scenario, what all the charges were, what the law is, what the court procedures are. That's where it gets very specific, and unfortunately, I don't have enough of the specific background knowledge of California to know that for sure. But if you said it's related to a parking violation, generally speaking, there's no way for that to then be bumped up to a misdemeanor. Generally.
Okay, it's because what happened is everything was done corrupted. I got assaulted in the IRS in California in Fresno, which the Homeland Security came, but they all committed perjury, pretty much all of them. I didn't know about no citations. Like I went to the ambulance. They said what it was my hand. They messed up my hand, pretty much. So 2 months come by, and we try to make a complaint because when they attacked me, the private security guards, our paper fell to the ground, which we had to notarize. We had private security, our Social Security, my daughter. But 2 months go by. We don't know how to make complaints against what happened or anything, and we get those parking tickets. My husband got 4. I got 4, and my husband gets 3. And this parking tickets, it said that I parked my car somewhere where I have a clean driver's license. I have nothing in my driver's license. I'm 54 and I have nothing. So that I couldn't call that date, and it didn't even have a case number, and it said it came from the United States District Court. When I called, which I recorded it, everything, the citation, she said, oh, I told her, yeah, I go, it doesn't have no case number or anything. We try to look. She goes, oh, these don't come with case numbers. And then she goes, she told me to give her a little name, and I even wrote it to her that said I parked my car somewhere. Well, she goes, oh, no, it has nothing to do. It's a probable cause and 4 citations. I'm like, what? I go, because the Homeland Security he threatened me. Thank God I recorded it. Everything was recorded from the beginning towards the end, which we end up in a United States District Court with a magistrate judge that I guess he already has a habit of doing injustice. And when we first went up in front of him, we told him we wanted a judge, and he refused. He refuses everything. Have a jury. He refused pretty much. He never read the probable cause either. So pretty much he covered up for the IRS what they done. There was never a police report. Actually, the assistant attorney generals did some crooked stuff because they found out that their own officers lied. We got an attorney paid so much money just to do nothing. Does the probable cause have to be read?
Well, I'm going to be honest, there's a lot that you're talking about here. So many different aspects of different elements of law and different factual things going on that it is very hard for me to be able to answer you with, to be effective in answering you. I'm not entirely sure about what you're talking about, but it seems like you were at, you said you went to an IRS building?
Yeah, I went to an IRS building. Before we went to an IRS, the reason I went to that building, we drove 2 hours, is because I keep on receiving these letters. They put my husband and me in 2 different addresses. Plus, we're asking them, and it was a formal letter, and we even looked up in the IRS. We were just there to submit letters. We were not there to meet with nobody. We were not there because if I wanted an appointment, I would have made an appointment. Plus, I have this loud voice that, and
So,
then you're telling things. So when we went there to the IRS to submit 2 formal letters and questions with attached evidence notarized, and for them to reply to us in writing, we didn't want to meet, and they were forcing us. The IRS workers acted like they were not managers or assistant managers. They pretended to be. So pretty much, we got assaulted. The private security said I could record it. I was recording when I came in, and he grabbed my phone and he knew I was recording. He opened my case, which I didn't say nothing to him because I just wanted to submit our paperwork. We just wanted to get in there and just submit paperwork. Nowhere does it say that you got to meet with somebody to submit a formal letter with questions and attached. They were forcing us, and I'm telling them, no, we don't need an appointment. We just want you guys to answer these questions. That way we don't keep on going in circles, and for them to write it back to us in writing. That way nobody's escalating, nobody's creating problems. My voice is not getting to nobody or, any of that. But I got assaulted really bad, which if you see in the video from there, thank God they gave it to us. You see how he snaps my hand. It's weird how you just see it. And this magistrate judge refuses to have a judge hear our case. He refaces
so
where does
the parking come into play?
I know, that's what I'm saying. We don't know. We even said when we did because we were representing ourselves, which we worked really hard on submitting our paperwork correctly. We did follow everything as soon as they knew how we did it. Oh my God, that judge was so mad. The magistrate judge, his name is Stanley Boone. He was so mad that they decided to go right away to trial. And they covered it. They threatened us with jail. If I try to make a complaint against what happened to me, it gets sent to the assistant attorneys from the and they start threatening me with my attorney fighting and standing. He didn't even do his job. Out of the blues, we never knew what evidence we're going to be submitted, not evidence not submitted. I mean, we've been through the rail with this. I mean, they're going to kill me. They're going to kill my husband and me. They convicted us with no right reason, and they rewrote the law. They put CFRs in that paperwork. Oh my God! If you only knew what we.
Oh, I have an idea. I have an idea because this is a public service, went through it, and I was his standby counsel the entire time. So, and he's still going through it. He's in the appeals process right now. So,
and that's what we need to do. We need to appeal and submit the right paperwork because we're trying to do our stuff. I'm not.
So
I'm
what is
scared.
the charge? What is the charge that you were actually found guilty of?
Of all 4, saying I didn't comply with signs in directions. The next one, littering, I prevented people from public service. Again, the same thing. Then another one, noise, that I made noise. And the reason that I made noise, because it's in the probable cause, they refused to read the probable cause. It's because when the Homeland Security, my hand was damaged. I was hurting. It's in my medical records. They cut my hand. I didn't know how he did it. I just knew my chest, my blood pressure. I could have died. They couldn't believe that I was walking. That's how high my blood pressure was. I was in tremendous pain. I thank God I recorded and the Homeland Security.
What is your question for me then? Because at this point, if you've already been found guilty, your next steps to fight it would be to appeal. So.
And that's what me and my husband are trying to figure. But it's like I feel like. There's so many people doing this stuff, but there's nobody somebody did our video of what happened, but then I don't know what happened. He did a great job, but we haven't exposed it completely for the public to see what really happened inside the IRS and how these, everybody committed perjury. Towards the end, they already,
hold on a second though, because I'm getting lost in all the information you're giving me. What is the question you have for me that I can help you with your appeal?
How do you start appealing your case? They put him in a center of violation viewers. and they rewrote the law. The law has been written. So that's not what it means in the real, are those citations?
Okay, so in order to start an appeal, in federal court, there you have to follow their specific process for doing that. And there is, what is it called? The online system, they have an online system where you can file your documents and all that. And they often have these formatted documents that they don't tell you exactly the substance of what to write, but they show you the formatting of what to write. But also in the court rules, in the federal court rules, you can see what it tells you exactly what you need to have: a statement of facts, a statement of jurisdiction, those kinds of things. It's actually in the court rules. So there's a formatted example of what it needs to look like. And you only have a certain number of days to do that. If you are...
Do you have to...
What's that?
I'm sorry to interrupt you. Do you have to do it after sentencing? Because we didn't, or before sentencing?
That is a good question about that. When is it considered a final judgment? So when you appeal, the general rule of thumb is you appeal when the case has a final judgment. If you appeal before a case has a final judgment, it's considered an interlocutory appeal, and it's a different set of rules that apply. In the criminal context, I'm not sure off the top of my head. I would lean towards saying you wait till sentencing is done, and that would be considered when the final judgment on the case has been rendered. So that you should still, even if there's a significant period of time in between when you are when you have a verdict handed down and then when you are sentenced, I would think that that's still not considered the final judgment until the sentence has come out. But again, that's going to be in the federal court rules, and I just don't have all that memorized. But you can look up the federal court rules, in a Google search. You'll be able to find them. Just make sure they're the official version. It looks like it's coming from a government website. But go ahead and take a look at those, and take a look at the table of contents, and you can walk yourself through the table of contents and find the section on how to start appeals and what that looks like, what your brief looks like, etc. The first thing I believe that you have to do is file a notice of appeal with the lower court, the magistrate level. And I could be wrong on this, but I believe your appeal is actually then going to be heard by a United States District Court judge. That'd be the next step up. So definitely take a look at the court rules and look at the court rules specific to your jurisdiction. So you not only have the federal court rules that apply, but then you have local court rules that are specific to, like here, it was the local court rules for the Middle District of Florida Federal District Court. So whatever specific federal district court that this case was held in, they have their own local court rules, and you'd want to take a look at that as well. In fact, sometimes it makes it even easier because sometimes they go ahead and give you even easier to use templates or spell out things a little bit more specifically that makes the process more streamlined for you. But that's going to be, so you'd most likely want to wait till sentencing, but check the court rules first just to make sure, because you don't want to miss any opportunity to challenge the conviction itself. You want to be able to challenge, possibly the sentence, but also the conviction. So,
And I was going to ask you, the notice to appeal, that it goes to the presiding judge first, I guess. Do I have to do that I am going to appeal it first, or do I have to still wait, like you said, after sentencing? Can I just file that notice of appeal?
Yeah, so generally speaking, I would say that any notice to appeal would come, again, after the final judgment has been rendered. but you want to double check with the court rules to make sure that that is in fact what it says, because I wouldn't want to be the reason why you have missed a deadline.
Yeah.
But generally speaking, it's any appeals documents come after the final judgment has been rendered in any kind of case.
Okay. All right. Thank you so much for your time. Thank you for listening, and thank you. And I'll start looking into it.
Yes, absolutely. And if you struggle with finding the rules, if you go to my website, restorefreedomkh.com, and type in court rules, I know at times in the past I have shared direct links through my freedom fighting tools. I've shared the direct links to be able to find those. And you should also check out the appeals videos that I have done that I talked about earlier in this episode. You should take a look at those too, because those will give you more specifics about how to kind of walk through the steps of your case.
Okay, I will do that. I'm gonna look and stuff and see what I could find and have my husband. It's because I have a little bit of a learning disability.
Well,
Pretty
it's tough
much.
anyway. It's tough anyway. I mean,
Yeah.
it can be
For
overwhelming.
for
So
everybody.
yes,
Yeah, that's going through this stuff when you try to, to do right in life, and then they do this to you, and then you have somebody that covers up for the wrong that they've done, which I don't know. You know how people say fake news. I don't know if the court system is becoming, with these magistrate judges, instead of doing righteousness and following laws, they disobey the laws. Like,
yeah. Well, it's not
then
just
they cover up.
magistrates. It's judges. It's justices. It's judges. It's attorneys. It's unfortunately touched every single kind of profession in our whole judicial system. So, but
Yeah, because they look at us like we're nobody. They're like upper ones. And if you ever did something wrong in life, they look at you like you're some, and they're very perfect, like, because the magistrate judge goes, you don't know the law. You don't know. I told him you should know from right, if somebody hits a car, if I told you right now somebody hit your car, you're going to go see. You're not just going to say, hey, me saying something to you. And I should have told them, you want to see that I do know the law because I'm in the Center of Violations. Can you please, assistant attorney, can you take out my driver license? Because you guys went and took you guys went and did my record. What do I have in my driver license? I have nothing. I'm 54. I don't have nothing. So obviously I do follow the law to the highest. Just because I went to the IRS to submit papers, and Mrs. That I didn't know how.
One thing I thought of real
Uh-huh.
quick, you're mentioning things that were mentioned in court. Make sure you get a copy of the transcripts from your hearings and certainly of your trial, and you want to request that right away. So,
Oh, I did. I already paid for the beginning ones. I
okay,
paid for the second ones, and I have one more. I just need to get the last ones. But I don't want to get those transcripts. I'd rather pay somebody else, because what I did do it the first time, and they wrote something that had nothing to do with the recording.
well, you have to
They
have the
made it.
transcripts to appeal.
Yeah, and
So
so I'm
just
gonna
make
pay for.
sure, yeah, make sure you get the transcripts from your trial so that you can appeal. So,
Yeah, that's what I'm gonna do. And stuff. Do you know? I mean, at this point, they use my video too, and they edited my video. The assistant, like the whole video wasn't presented what really happened,
okay.
because they already knew. They were saying about a poster. The post. How they go around putting in these buildings.
The signs,
Um,
the
yeah,
posters that show that you
those signs.
can't record.
Record. Yeah.
Yeah.
But obviously, the law is the law. We weren't even was told to this magistrate, but he didn't care. He doesn't follow the law. I mean, there has been overturns of what he has done, almost similar to what he's doing to us. But I guess what,
Yeah.
I don't.
No,
So pretty much,
that's definitely something that's happening. That's why this is a public service is fighting and appealing his case right now, because that's what he was convicted of, was violating these signs. You can't violate a sign. I mean, that's not a law. But they tried to say, well, he violated the CFR, and the CFR said if there's a specific directive, and then they just point to the sign and say, well, that's a directive. No, it's not. It's a sign. But
and the
anyway,
good point, yes,
so it
and
happens.
they said is rule. No, we're not. We're not there for rules. We're there because, and even in the Homeland Security, it's set right there. We have the memo. We have it all where it states, but this magistrate judge didn't care about it,
Yeah.
because he already said, I am the judge. When we're telling we won. When I told him, can you read the promise card? No, I don't have to. It's like he's spiteful to us. He didn't do what he's supposed to do.
Well, that's the whole point of an appeal, is that it's going to a different judge. So what you need to do is make sure you have all your ducks in a row, make sure you have everything documented, and keep in mind that in general, you can't introduce anything new that you didn't introduce at the trial court level. Now, if he stopped you from introducing some piece of law or evidence or whatever, but it's on the record that you tried to get it in, then that's good enough to preserve your right to bring it up later on. So just keep that in mind.
Yeah.
But
and you know what? When the cop came in, he limit to ask him questions. So the magistrate judge limit. You couldn't ask him questions. Then he said, "Oh, I'm going to strike that." Like if he was acting like he was the lawyer and the assistant. He said, "Oh, I'm going to strike what he said out of the record." So
again, that's why you get the transcript, and that's why you highlight what all the procedural problems are, and you bring those up in your appeal. Absolutely.
Okay, I will. Thank you so much. And if I have any other questions, I hope you don't mind me calling. And thank you.
Yep. Have a great day.
You too. Bye-bye.
Okay, guys. So, in the meantime, I'm going to go ahead and head over to the questions here. Okay, so that's right. Liberty Lisa, I'm back at your original question. I will scroll down to see if you had anything else to say about it. I just wanted to make sure, I hope that I was able to answer your question as I was trying to wrap up my statement on that while the last caller was calling in. But yeah, as far as, I'm just making myself notes here about that. But as far as property lines go, again, if there's no zoning ordinance, if there's nothing in law that specifically says to someone a legitimate reason why they cannot build within so many feet of the property line, they can use their entire property as they see fit. So, some common considerations for why it might be a legitimate reason why you can't build right up to the property line is if you're going to change the water flow, drainage, or cause some other kinds of issues that don't otherwise currently exist, where perhaps you are going to then make your neighbors' properties flood or something of that nature. Those would be things that would be considered as far as where there could be legitimate reasons why you can't build right up on your property line. But anyway, so if there is nothing on the books, though, if there's no law, local, state, or otherwise, that says they can't build within a certain amount of feet of the property line, then they can. Okay, so well, and as far as questioning the property lines, that's as simple as getting a survey. And that's something that people should be doing anyway, especially when they have a contract. But generally speaking, most municipalities or counties at this point use GIS systems where you can go online and they show an aerial view of the entire area, and they show the property lines. So that's a good starting point, and that should be enough for somebody to then feel comfortable about whether they're going to put a bid or make an offer on a property. And then I would definitely make an offer contingent upon the survey being properly matched up with what the representation of the property lines is. Or if you just want to save, if it's a big enough problem right now in the marketing aspect, get ahead of things and go ahead and get a survey done now and have the surveyor really, market, other than with typical, small survey spikes, have some sort of cones or something else out there that can really draw attention to where that property line is. and be able to show, I mean, document it, make a little video that you can attach to the listing, or have pictures or something of that nature. So there are ways that you can easily demonstrate for people where the property lines are. Okay, so I see a lot of chat back and forth, but and then, of course, there's Blue Line Transparency providing an update, not on a case, but just to say that flights to LA are half price this week. Did you guys see, by the way, that, and I haven't read the full articles on it or the documents in court, but Gavin Newsom in the state of California has actually sued the Trump administration for providing the National Guard troops to go to LA when officers are being, first it was just the ICE officers, and then it sounds like even LAPD and other people, other law enforcement officers are being violently attacked, to the point where even the chief of police of the Los Angeles Police Department made a public statement saying that the first day was bad enough and violent and abhorrent, and, you know, really condemning that behavior of the rioters, but then talking about how it was getting progressively worse every day. And, you know, at that point they had only, you know, they'd already made 60 arrests, but it was, I mean, and I've only seen very limited camera footage from what's going on there, but where they're setting vehicles on fire, where they're literally people that are just passing by on the street, people that have nothing to do with ICE, are literally driving their vehicles, and people are assaulting them and trying to damage their vehicles and stop their vehicles as they're just trying to drive and get by on a road that's nearby what's going on. It's ridiculous. That kind of lawless behavior, I cannot wrap my mind around why the left defends that stuff, and why Gavin Newsom would take it a step further. I mean, 50 steps further. We already thought he was insane, but I mean, come on. You are going to sue the federal government for trying to stop the violence in the state of California when you can't get off your own ass and do it? Are you serious? There's so many things. I would assume you wouldn't be joking that flights would be half off, because who would want to go there right now? I do feel bad. I will. So we've been going to a new church in the last, 6 months or something. And we are part of they call them care groups. So it's, a handful of families, like 5 families or so, that get together. Some of them might get together once a week. Ours gets together typically twice a month, and have dinner and pray and have fellowship and talk about the sermon or whatever, just a time of fellowship and growth. And usually the adults get together and talk, and then the kids go off and do their thing together. And so at the end of the evening, we were getting ready to leave, and one of the families, super awesome family, they're Christian conservatives, okay, and fairly recent transplants to Florida as well from up north. But anyway, so they are getting ready to leave. In fact, I think they might have left yesterday on a trip to California, and they're going to look at. I want to say they were going to go to the Grand Canyon, and they had all these sightseeing places that they were going to go and look at, and national parks and things like that. So anyway, the main stop or whatever is going to be, national parks in and around California. So their 10-year-old daughter was talking to Emma, my daughter, who's 11, about this. And so their 10-year-old daughter tells Emma, oh yeah, we're going to go to California on vacation. And Emma says, why? California sucks. And I was like, well, yeah. I mean, to live there, it sucks. But, we personally don't ever really want to visit there because of the chaotic nastiness and things that ensue. And because I am not one to, if I see an injustice happening right before my very eyes, I am not going to be the one to just drive by and pretend I didn't see it. So, I don't want to go to California ever. But anyway, I felt bad because, my daughter, let the, anyway, it was quite an interesting exchange between them. Oh shoot, I just saw a new question and it did that thing where it scrolls. Oh boy, did it scroll a lot on me? Oh, okay. Okay. Can you file a motion to dismiss based on specific facts in a small claims case? Ooh, that is a good question. So in general, small claims cases are not, they don't follow the typical, see, it happens every time. All right. Hello, this is Catherine. Who am I speaking with?
Hi, Catherine. It's Jerry from PA.
Hi, how are you today?
I'm good. How are you?
I'm doing fine.
I'm sorry.
I just said I'm doing fine. So what's your question or update today?
Okay. We're back to the zoning hearing board again. And the group, the business that put in for the group home, put in an appeal on the judgment of the zoning board. It's called a writ of, and you have to correct me on if I'm saying this right, certiorari, something like that.
A writ of certiorari. Okay.
Certiorari, yes. I called the attorney on the zoning hearing board 2 weeks ago to get the transcript of the hearing and plus the court filing, and I have not received anything yet. So I'm asking you, what would be my next step here?
You said that was by phone call?
Yes. I called his secretary and I called him.
I always do things in writing. So what I would do at this point is send an email and go ahead and state, very clearly in the subject line, that it's regarding an urgent current case matter. If you have a court file number, whatever, great. Put that in there. And then immediately identify in the body, identify who you are and that you are on the zoning board and that you are involved in this this lawsuit that's been filed, and state that you called on such and such a day, and say, I called 2 weeks ago on this day at this time and I left a message. I talked with your secretary, whatever the details are. And I'm simply requesting these two things. And then I would even kind of go down in from your paragraph and put a 1, indent, put a 1, and then state, I want the transcript from such and such date, and 2, and then state, so whatever you're identifying there, and then come back into normal paragraph form and say, this. I expect a response within a reasonable period of time. You work for the zoning board, and I am a member of the zoning board. So, I expect a reasonable response to be provided within a reasonable period of time. And at this point, since 2 weeks has already passed, I would expect that you would be able to get this sent to me within the next 48 hours or something of that nature, and put it in writing. And depends on how, I don't know the politics there, and I don't know enough of the nuances of different procedures and things like that, but at times I am not afraid to allude to, listen, I have no problem bringing this to the media if you are going to sabotage our right as public servants to get information, public information that should be available to anyone in the public, let alone me in this position, when the government body that I am serving on has been sued because they voted in a way that violates the law and violates someone's rights. You know, I would, again, you have to, more about the situation and, like I said, the politics and whatever, because your end goal is to get the information. So it's not that I'm all about, sucking up to somebody or being too overly worried about somebody's feelings. That's not the point. The point is, practically speaking, what is going to get you the information that you are needing in the fastest way possible. And so sometimes it's alerting them to, hey, you're going to have a bigger problem on your hands if you don't just do the right thing and provide the information. Or sometimes it's just letting them know, listen, I'm here and I'm not going anywhere. I've now put this in writing. I'm going to give you the benefit of the doubt that perhaps you got busy and because it was a phone call, you forgot to come back to it. But now it has been 2 weeks and I'm putting this in writing, and I expect a written response, with these documents accordingly. So you just got to gauge the situation and figure out what's the best way to have, what kind of tone to that email that you want to have that would go about getting the best, the fastest and best response. So.
Well, I have a council meeting tomorrow night, and I was going to bring it up at the council meeting because somebody's been deleting my emails on my zoning email account.
Well, hopefully.
So there's something going on.
So make sure what you are doing is that you can copy your own personal email when you send all emails. That would be one way, because then they can't go in and delete those, right? And you can save things as a PDF. So if you need to go in there periodically and, like act like you're going to print it, but just save each email incoming and outgoing as a PDF so that you have that. I would definitely be doing that if somebody is trying to delete your emails out of that account. So I would still send things out of that account, but I would put it in writing. If you have a meeting tomorrow, I would go ahead and make sure today that you have put that on the record in writing, that that email back to the attorney's office. And then I would also put it in writing somewhere and copy anybody and everybody that you think would be appropriate to include as to the fact that you are having somebody is getting into your email account and they are deleting emails, which is, it's a violation of so many different procedures and policies there, because they shouldn't be deleting what you're working on because that's your work. But secondly, they shouldn't be deleting anything like that because it's a matter of public record, and it would be available it needs to remain available if somebody ever made a FOIA request and they wanted to access those records later on. So there's a lot of reasons why no one should be in there deleting it. So you might want to make a public inquiry as to who all has access. In fact, go ahead and make a FOIA request to identify exactly every single person who has any kind of access into your email account for that zoning email account. I would definitely do that.
That's an excellent idea.
And then make some noise about that and copy whoever you might need to, because there's some issues. The more you can appropriately, it's all CYA with anything, anybody. The one, if I could only give one piece of advice from now for eternity on any kind of case, it would be CYA. And phone calls generally don't have the CYA type of enforcement that emails and things like that do. Emails are great because they are date and time stamped and all that. And again, you just need to make sure you're saving copies somehow. And it wouldn't hurt to double up. If you want to make sure all of your emails are copied to your a personal account. In fact, even make make yourself, like when I worked as a trustee in Georgetown Township, we were told to just make ourselves, like, we could make ourselves a Gmail if we wanted to that was specific to that. And I don't remember exactly what mine was. It might have been Georgetown Township .catherinehenry@gmail.com or something like that. But the only business transacted in that account was for the Georgetown Township stuff, right? It was, when citizens emailed me, or when meeting packets were sent out to me, or, when I had questions to the treasurer or the clerk or somebody, right? So at any rate, if you go ahead and make, let's say, a Gmail account specific to, this work that you're doing, just put zoning and then your name at gmail.com or something. At any rate, that could be your backup, where the only thing in there is where you are, copying, blind copying, whatever. In fact, I would just blind copy all of your emails over to that. And you can even set up ways to have that email account automatically forward your emails that your incoming emails. You can have it set up to forward all your incoming mail over to that Gmail account. So there's some ways that you can do that on the Gmail side, as well as, within the settings of whatever other email server that you're using, that they set up for you. But anyway, go ahead and get that set up right away. I mean, like today, and make your FOIA request today, and send out that email first thing before those other things. Go ahead and send that email out to the attorney to make it clear what information you're requesting, and who you are, so they know there's some timing necessity to this. So.
Okay, thank you. I will
Yes.
do that today.
All right, sounds good. I look forward to hearing an
Appreciate your
update.
time.
No problem. Have a great day.
You too. Bye.
Okay, guys. So let me see here. Okay, let's go back to the questions. Okay, so John was asking, can you file a motion to, let's see. I'm going to go ahead and switch over here for a second. Okay. Can you file a motion to dismiss based on specific facts in a small claims case? Facts are a little harder to dismiss on in a motion to dismiss. I don't have all the specifics off the top of my head for common motion to dismiss reasons. There's at least 10 of them. So, but at any rate, generally you get cases dismissed a little bit easier when it's based on a legal issue and not a factual issue. Generally speaking, factual issues are supposed to be determined by the trier of fact, which in a small claims case is going to be your magistrate or your district court judge or something like that. So can you file a motion to dismiss? In general, yeah, I don't know, a motion to dismiss based on facts. Again, I don't have all of them. I mean, I know, in Michigan, 2.116C4, I think, is the subject matter jurisdiction. 2.116C8 was one I commonly used. I want to say that's failure to state a claim upon which relief can be granted. 2.116C10 was one that failure to, yeah, there is very similar to C8 in some respects, but they're legal. C4, C8, C10, those are going to be legal reasons. You have personal jurisdiction. I'm just trying to think of other ones, what the other ones are. I just don't have enough of them memorized off the top of my head right now. But I'm not sure. I'm inclined to say no, that you can't do a motion to dismiss based on specific facts in a small claims case, because that's something that the trier of fact would have to determine at the time of trial. but I could definitely be wrong on that. Okay, so let's see. I'm not seeing any other questions yet. There was a lot of great conversation back and forth. It looks like, what in the world? Black Quiver, I'm not sure what you're doing to me here. I guess I'm able to see it, but dang, your your font there. I don't even know how you change font and do things like that in a YouTube chat. Does Trump have the right to use the military in California? And is it martial law? That's my question. I honestly haven't had a chance to read the articles about it. And ironically enough, I had them saved in my drop down of notifications. And when I woke up this morning, they were gone. So I'm not sure what's going on with that. But so I don't know exactly what he's attempting to do there. My inclination is to say, no, it's not martial law. It's not anything to affect the citizens who are not engaging in the lawlessness, but rather just trying to suppress the violent, lawless behavior of the rioters themselves. So just have more law enforcement officers out there to literally repel the violent attacks. They were having the LAPD chief of police said that they were actually using commercial grade fireworks and setting them off at the direction of law enforcement. That could kill you. That is definitely a violent offense. Definitely not at all a peaceful demonstration. So anyone who is engaging in those violent acts, my understanding is that they, well, and put it this way, ICE was out there asking, you know, when this started, when it all started, whatever day it was, I don't even know. Was it Saturday maybe? When it started, they were asking for assistance from LAPD for over 2 hours before any backup showed up from LAPD. That is insane. I'm not sure what's going on there, but that is not acceptable. And I mean, the whole point of PD, police department, is that it's within the confines of the actual municipality that you're seeking help for. So it's not like you're asking for, you know, for example, they didn't call to say, hey, can we get National Guard backing us up right now? No, the first call was to PD, the local police department, and they took over 2 hours to show up, and you had officers being injured and definitely having the threat of having their lives ended by what's going on. So I don't think it has anything to do with martial law. But anyway, that... Okay. Well, and as far as anything being too late, I just happened to see, this isn't a question, this was just discussion, but ex-bootlicker was talking about, I want to say it was Liberty Lisa that had asked a question about property lines in Washington and a house being built too close to her property. Okay, I'm not sure what happened there. So anyway, the he's saying it's almost too late. How are they going to make them move the house? Well, you can certainly make someone move a house. So for example, let's say it wasn't just that it was too close. Let's say they built it on encroaching over onto Lisa's property. Lisa absolutely has the right to make them tear down the house if it's on her property. Hello, this is Catherine. I am not sure what's going on here, but the first time it shows that I answered and they got disconnected somehow. The second time it's showing I didn't even answer even though I hit the green button. So if you are the one calling from that 586 area code, please feel free to call back. But anyway, so yeah, just the fact that it's already up doesn't mean that they can't. In fact, let's look at my case. Ex-bootlicker, I don't recall you being someone who's commented on the case before or on this show before. Hold on a second. Hello, this is Catherine. Okay, so I answered again. I'm not sure what's going on there. if you are in fact new to my channel, you might not know at all about my case with the city of Ormond Beach. And the city of Ormond Beach is trying to get me to tear down a privacy fence that is complete. They're trying to make me dig up pavers, parking pavers, in our property, in our yard, and to remove two shipping containers that you can't even tell are on the property. That they have determined are a garage, and city code says you have to have garages here, and that's the only garage we have, so city code says we can't remove them. Anyway, they think that they not only can make us tear it down, they initially were trying to get an order. They got an order that said they could come and tear it up off our property. I have no idea what's happening with this 586 caller, because we are really struggling on getting connected here. So if you want to try one more time, let's give it a go. It only rang for about a second and a half, and then it disappeared, so I couldn't even have time to answer it. Anyway, okay, so let's see, were there any other questions? Did it just do what it always does? Oh boy, it did. It scrolled on me. Sorry guys, if I am missing a question that you guys posted. I tried to scroll back and get to where, let's see. I'm not seeing any questions, so I'm just making sure if you guys had a question, I am not trying to ignore it. I think, oh, John Q. Public, that's you trying to call in. I am not sure what's going on there, because I have answered it twice, and then twice it says that you hung up too quick before I could even get to pressing the green button to answer it. But and in the meantime, Lori has posted the filings, the direct link to, you could see everything that's been filed in this case, even what was just filed last week. Court of Appeals decided to make it even more challenging for me. Okay. So, I'm going to give you guys a quick update in the meantime to see if we can get this call from John Q. Public to be successful. But in the meantime, yes, cell phones do suck. In the meantime, I'm going to go ahead and give you guys this update. So, for those of you who know and just need a very quick reminder, our case, okay, here he is. Let's see if we can do this. Hello, are you there?
Hello, ma'am. This is Eddie. I'm here.
All right.
Thank you, public, in the chat, but it's Eddie. But anyways, yeah, I was just trying to call in with an update. Like I said, I had my court date was supposed to be yesterday, and I got a letter saying that the motions to suppress and the motions to dismiss both got denied by the judge. And I didn't even have a court date or anything. This was happened before even the court date. The court date was supposed to be yesterday. And then I get contacted by the court-appointed public defender, and I get told that, oh, well, no need to go in tomorrow because the judge has already ruled against the press. So now the court-appointed attorney has between now and the 23rd to rewrite the motions and submit the motions or anything else that they want to do for the trial. So this was, I mean, these motions were not even ruled on even before the trial was going to begin. She was going to start the trial before any of the pretrial motions were ruled on. And now she conveniently just says, oh, no, we're not going to have the motion to suppress. We're not going to have the motion to dismiss, and we're going to start trial on the 9th. Well, then I get, like I said, I get the letter from the court-appointed attorney saying, well, now we don't have court on the 9th. It's been suspended so that I guess the motions can be rewritten or redone again, and now we're not supposed to have trial until the 23rd. My concern is, wait a minute, I wasn't even included in any of this process. It seems like there's been a lot of discussion, or I guess my question is, why are discussions, and I think you guys call it in the legal realm, ex parte discussions, why are ex parte discussions happening without even myself being present? And I've actually seen this happen in the Lane Meyer case as well, where there's been a lot of ex parte discussions happening between the prosecutor's office and the judge, and a lot of them are not including Mr. Myers or his court-appointed person. And it seems like the same thing is happening in my situation, where there's a lot of discussion happening amongst the attorneys and the judge, and I have been kept out of the process, or I've not been included in the process.
Okay, so it's not called ex parte communications if your attorney is involved. It's only ex parte communications if somebody from the other side
Are you
is
there?
involved. Yes, can you hear me?
Hello?
Yes. Give me a second here. I'm not sure. Can you hear me?
Hello?
Okay. Can you hear me?
Yeah, I can hear you now, ma'am. I'm sorry.
Okay, I don't know what's going on there. Okay, so just for what it's worth, I'm going to pause for a second. Can somebody in the chat tell me if you could still hear me as well? Because I changed a setting on my microphone to see if that could help him hear me, but I didn't want to make it so that it only works for him and you guys can't hear me. So anybody, somebody, Lori, Jake Hervit, Black Quiver, anybody in the chat, please comment if you can still hear me. I mean, it looks like my mic should still be working and all that, but I just want to make sure. Somebody, anybody, somebody. Okay, good. All right, I just didn't want to go into a whole big thing and then they all start coming after me. Hey, we can't hear you anymore. So the main thing to consider is that ex parte communications only occur when one side has communications with the judge and the other side is not represented. So it might be a party, it might be the attorney, but I mean, unless there's more information that you have for sure, that you didn't convey to me, it sounds like potentially your attorney was involved and the other side's attorney was involved, or better yet, it was just it could have been as simple as nobody had direct contact with the judge. But for example, when I served as a public defender, or really as an attorney, you know, in any court, if I was especially a common attorney, like I might have been there for John Smith's case, and the court clerk just happened to say, oh, hey, by the way, did you see that your case tomorrow is off the docket? I'd go, oh, no, what's going on with that? And they could tell me, and then I'm like, okay, that doesn't necessarily mean I had communication with the judge about it. Do you know what I mean? Or it could be that the attorney just somehow got some electronic notification that there was an update to the docket, or they could have just been looking at it themselves. So, you know, there's all kinds of things. Oftentimes, courts will post a printed docket for the week, for the days of that week up, you know, on the wall somewhere. Outside of the courtroom, or, you know, in front of the clerk's office somewhere, something like that. So it could very well be something like that. And you were calling from Michigan anyway, right?
Yes.
Yeah. So that is a common practice in Michigan. So it's not considered a bad thing if your attorney and the other attorney are having conversations with the judge, as long as your attorney is included. Now, unfortunately, you know, you can't always trust your own attorney, but that's a totally separate issue. That's not meaning that the court is doing something wrong or that the prosecutor is doing something wrong. Sometimes it's just, you know, if there is something bad happening, it could just be that, you know, your attorney is doing something wrong. But I wouldn't assume at this point, like I said, there could be a lot of different reasons as to how your attorney came to this information. So I wouldn't assume that your attorney was involved in any kind of backroom dealings. As far as the judge dismissing, have you actually seen an order that says that those motions were denied?
No, as a matter of fact, because this whole thing got prolonged because evidently the person in his office that does multiple things, including writing up the briefs and the motions and everything and typing them up and everything, evidently got her arm broken or whatever. So there's been many delays in this here. And the most recent appearance when I went in, he had some underling, really low or high P bar. So like my public defender has his P bar, his number is like in the 30,000. And this attorney's P bar number is in the 80,000 number. So somebody relatively new. And she did not know what was going on with the case. I didn't even know who this was in the courtroom. And she says, yeah, I'm here to step in for your, I'm not going to say his name, that court-appointed public defender. And I'm like, do you know anything about this case at all? She says, no, I'm just here to get more time from, the judge. And I said, well, the judge is at her wit's end with this here. She's kind of ticked off that it's taken so long to get these motions done. And, the judge is like going to take that out on me instead of out on the attorney. And so now I get this, we were supposed to start trial, like I said, on the 9th yesterday. And then I get found out that the judge ruled against the motion to suppress and the motion to dismiss on the Second Amendment stuff. And this is after I give him all the information that I could possibly give him on Second Amendment, since he's never taken up a Second Amendment case ever.
But let me pause you for a second, because you're
yes,
kind of going over quite a few things.
I'm sorry.
You got a letter that came from the court's letterhead that said the case. What did you get that said?
I got an email.
You got an email from your attorney?
His law office, but it wasn't written by him. It was written from the, I guess the person that's like the paralegal or,
okay.
The person who writes up the motions or whatever.
I would, how close are you to the courthouse?
Right now I'm at a distance because I'm staying with relatives right now.
Okay.
For my security, my safety.
Because what I was going to say is, if some courts have their docket where you could see it online, but if you can't see their docket online, I would go and ask for the Register of Actions, which I realized to some of you, you might not have ever heard of that, and they might not have that in any other state other than Michigan. But in the Register of Actions, it's essentially the docket, but with even just some notes about things. It's not just limited to when there's a court hearing or a document filed. Sometimes it's like, oh, I got a phone call from so-and-so. So I would ask for a copy of that Register of Actions, and they might be able to email it to you if you called and asked them. But just say that, there's been some confusion and you were told that the judge denied your motions, but you have not seen an order denying those motions. And so the Register of Actions would show sometimes a judge will just simply deny on the record, go on the record and just say, I am denying these motions, whatever. But again, that would show up on the docket or on the Register of Actions. So you need to get from the court itself what the actual status of that is, and then why. So if there is, if it was something that was stated on the record, perhaps the notes in the Register of Actions would say why the motions were denied. Otherwise, if it's in writing, hopefully that would say why. Otherwise, if it was on the record, you might have to get a copy of the audio or a transcript or something, which you should be able to do. But I would do it like now. I would do it today to figure out exactly what's going on, because something doesn't quite seem right there. I've never just told my clients that, a motion has been denied without showing, if there was a paper order, showing them that, or if there was a hearing to say, well, on the record today, the judge denied, something so they know exactly when and how and why. So it could just be miscommunication from that law office, or it could be that it's a misunderstanding by the law office and something, either way, if I were you, I'd want to know exactly from the court's perspective. And if they were denied and you have time to refile motions, then there's a specific reason why. A judge is not going to push a court date out and give you time to refile motions they've just denied unless they are specifically giving you the reasons why, like, okay, these were not done in this proper format, or they didn't have whatever it is that they're claiming is missing. There's something, it seems to be procedural wrong or defunct with those motions. And perhaps if it was kind of like a malpractice issue with the public defender's office, that might be why they didn't give you the specifics. So if they're trying to cover up the fact that they were told that they didn't do it right, and they're given a second chance to try to do it right here. But whatever the case is, contact the court and get that register of actions and figure out what's going on for sure.
I just find that amazing that a judge would be able to do because, I mean, like I said, both arguments were pretty solid and they're both constitutional issues. And then, a district court judge, which, are I guess it's been said before that any of the lower courts below the Supreme Court or inferior courts would be able to just dismiss motions made on constitutional issues and just totally ignore it. I mean, that just is amazing to me. But what do I know? I'm just a regular plebe and, serf and servant just like anybody else out here. So,
yes, it's amazing that they think that they can just do what they want. But then again, there's a reason why I was, I've raised constitutional issues at virtually every hearing that I've had. And it's amazing how judges or magistrates will just say, well, I'm just, nah, that's without merit. Could you tell me how they're not bound to follow the same constitutional provisions here? How exactly is that without merit? Or they just completely don't even talk about it? So, doesn't surprise me, but at any rate. Well, yes, let us know how that goes. Right,
and this again is not only the federal constitution or our national constitution, our Second Amendment, but again, referring back here to Michigan, and this is in every state pretty much. Yep, Article 1, Section 6, and so it's our state constitution too.
Yep.
And I'm sorry, I'll wrap up with this. I even wrote up being previously in the legislature before. I actually just got done writing up legislation, a House resolution, so they could, and I've been up to Lansing several times to meet with pro-Second Amendment legislators, both in the House and in the Senate. So that would be, the Binsfield building and then the other Anderson building. And been up there, spoke to like at least 13 pro-Second Amendment legislators, and they reviewed the legislation. They said this is pretty solid, but it was like 17 pages. And just like, when you have to write up a legal brief, you need to have a certain format. You got to say whereas and what's resolved and so on and so forth. Just like a legal brief, you have to have a double spaced and a certain font and so on and so forth, a certain format. And they said it was pretty solid, but it's just like they're thinking, well, because we have a Democratic legislature, they're not going to follow the law, even though the law is on the books. And Dana Nesso feels that she doesn't have to follow the law either, just like we have Jocelyn Benson doesn't feel like she has to follow election law. It's just there's no accountability. But then they'll hold, the people that go to work every day and, just try to pay our bills and, live through life. They'll hold us accountable to something they don't want to be held accountable to.
Exactly.
Okay. I'll leave it at that. I'm off my soapbox.
Sounds good. Have a great day.
All right. See you, man. Bye now.
All right, guys. So I don't see any more questions. I just kind of scrolled a little bit more and don't see any more questions in the chat for me. So I'm going to go ahead and throw some of those links on the page. Of course, our main website is restorefreedomkh.com. And we have restorefreedomkh.com/donate. That is going to be the one place that I hope that you do check out sometime in the next couple weeks here. Donate what you can. Anything at all helps, but all this stuff costs money. And quite honestly, there's been many years that I ran my entire law firm without even having home internet. I have home internet now, so I could do these videos and be able to help you guys. So even that cost is an added expense to us. So anyway, if you can donate a one-time donation of $5, $25, $50, $100, or if you want to make it a recurring donation, there's ways on Cash App, Venmo, PayPal, checks, all of that. It's all written right on how you can do that with links as appropriate on that donate page. And Lori put the link in there as well. The case that I was talking about with the city of Ormond Beach, restorefreedomkh.com/OB case. Oh yes, before he finally called in again, I was giving you guys the update that the Court of Appeals decided to, the court clerk for the Court of Appeals decided that, let me back up. Okay, so we have this case. It has started, it's been almost 3 years that we've had this case. The city first contacted me about my pavers, my fence, and my containers September, I want to say 2nd of, might have been September 1st, 2022. We had our first hearing February 27th, 2023. That was with the magistrate. We began our case, our appeal, in the circuit court March of 2023. We had several hearings and oral arguments and of course, briefings and all that. And she decided the case. Her final judgment from that appeal came out in March of 2024. She ruled in part for us, saying that they could not come on our property themselves and physically tear up our property, dig up our fence, dig up our pavers, and take our shipping containers. She said that they didn't allege the proper facts and law to make that an okay thing to do. But she did say that they could fine us for all infinity, and that my legal arguments were inarticulate and whatever, inartful and whatever. Like, she's throwing insults like it's going out of style, as though that really has anything to do with anything. If the law supports what I'm saying, even if you don't like how I'm saying it, you still got to follow the law. But anyway, so she got a bunch of the law wrong, unfortunately, and especially about my Eighth Amendment issues. She said that I lost the ability to raise the issues because I had to raise the Eighth Amendment claims at the lower court first. Problem is, I was denied the opportunity to speak on the Eighth Amendment issues because I didn't know what the sentence would be, if you will, the amount of fines and all that, until he said it at the very end of the hearing, and then concluded the hearing without any opportunity to speak at that point. So anyway, and I did raise the issues afterwards in writing to him as well as to her in my initial motions. But anyway, so I filed the circuit court's final judgment of my initial appeal was handed out the beginning of March of 2024, and March 7th is when I filed my first, it's a petition for writ of certiorari. It's essentially, in Florida, it's treated as a whole new kind of an original jurisdiction case. It's not treated as just the next level appeal, but really it is a next level appeal. So anyway, my petition is essentially, it's a brief, right? It's a brief. It's like the same, basically the same format and layout and everything of my appellate briefs that I filed at the court below. Very, very small nuances or differences between them. But anyway, I filed that April 7th, and they made me, so you have your brief, and then you have to file an appendix, which has basically the whole record of things that happen below. Anything that you're going to reference in your brief or allude to in your brief or your petition, you have to have those in an appendix. And so I put all that together, and that thing was like 600 pages at this point. I mean, it's been an insane case, taking, almost 3 years at this point. So I followed court rules, and anyway, they denied me for filing. They accepted the petition initially, but they denied my appendix. And then they made me change the appendix. And then they made me converge. I had transcript and appendix, because at the lower court, that's what we were required to do. So I purposely kept them separate. And this time they said, well, no, you got to have them together. Well, there was no court rule that said I had to have them together. And there was the court rule that at the lower court that said I had to have them separate. So anyway, I did what they asked and I merged them, but then my page number references were wrong in my petition. So then I talked with them on the phone and I said, I gotta send in an amended petition that all it's going to do is update the page number references because you have had me change my appendix. So I filed that and they accepted it. And they accepted eventually my brief. There were some issues on their end with technical stuff. They couldn't see some of my pages. They couldn't see my bookmarks. It was nothing on my end. It was their viewer was having issues. And so I eventually was able to figure out what the issues were and I was able to fix it and get it filed. In the meantime, then they let it stay on the record for like 2 days, 3 days maybe. And then they said, oh, no, strike that. You have to rewrite this to take out. There can be no pictures, no graphics, no charts, nothing within the body of your petition or brief. And that really sucked. There was no court rule that says that. There's a court rule that says, your evidence has to be in an appendix. It doesn't say it can only be in the appendix. So I had to take it all out and then rewrite, the wording to account for how am I going to reference this, and basically telling them then, okay, well, instead of just referencing what's below, you now have to go to page 512 of my appendix. Anyway, and I also had a footnote on the very first page of that second amended petition that said to them, by the way, it is an encouragement by, for example, in the State Bar of Michigan, the State Bar of Michigan Journal, I was able to cite 2 different publications that were encouraging specifically attorneys to use pictures and other diagrams and things where appropriate to bring life to briefs and petitions. And that's exactly what I did. If we're talking about what my pavers and my fence look like, don't you think they should see a clear image of what my pavers and my fence look like? We're not talking about something that looks chaotic and ugly and scary and it's a nuisance. Not at all. In fact, that's not even what's alleged, but it's important. A picture is worth 1,000 words. Or when I get to the section talking about the fact that you can't, the city code doesn't allow you to put pavers, towards the center of your property line to extend your driveway. You have to put them this way. But at the same time, they are saying that I can't have them within 3 feet of my property line, but I have to have them. Each parking space has to be at least 9 feet in width, and I have to extend towards the outside of my property line, not towards the inside. There's no way to really let those words sink in. It's too convoluted of a concept. The only way to do that is to show them in pictures, right? So I spent hours, and Mike helped me. The 2 of us spent hours. I probably have 15 to 20 hours just on the diagrams alone that showed with different colors. Okay, red is showing this part of their city code. Blue is showing this part of their city code. Yellow is showing where it is. All these things so they could see exactly where, in reference to my driveways that were already here and the house that was already here, what's going on. And if you guys are interested in this, you can go ahead and take a look at that website, restorefreedomkh.com/obcase, and look at the Court of Appeals filings that I have. And those graphics are in there. They're in the briefs. At least the second amendment petition. I might have, if those aren't on there anymore, then you'll see it in the appendix. It's at the very tail end. Start looking at page, I think it's maybe 512, and then look to page 519, 520, something like that. But it's at the end. Scroll and then you'll be able to see those. So at any rate, that was the second amendment petition. Then they waited until 6.5 days after my emergency surgery, the third surgery that I had within, 3-4 period of months. But less than a week after my emergency surgery, they issued an order out of the blue, right? They hadn't done anything since April 11th. In fact, when they ordered me on April 11th, they scratched my first amendment petition and they ordered me to file the second amendment petition without the photos in the brief itself. They gave me 10 days to file it. The 10th day would have been Sunday, so I actually had 11 days. The next day would have been the Monday. I filed it. I fixed it and filed it that exact same day on April 11th, 2024. So I filed it 11 days early. All of these things I was doing exactly when they told me to fix it. That day I was fixing it and I was filing it. So at any rate, and the brief itself, initially, the initial, petition was due on the 8th, and I filed it on the 7th. So I filed that one day early. I would have filed it even earlier, but it was a lot to go through, and I was busting my butt to make sure I was cross-referencing all the court rules and statutes and things, and that I was doing everything by the book. Because remember, I'm not a Florida licensed attorney. I've had to teach myself this as the case is going. So at any rate, they tell me that my brief is too long, that it appears too long. That's literally the wording they used. It appearing that this brief or that this petition is too long, you're ordered to shorten it and you have 20 days. I wrote back and I said, first of all, I made an emergency motion that same day, very timely, okay, that same day. And I said, listen, I don't have, the court rule says we're allowed to rely on our word processing software to give us a word count. That is exactly what I did. I relied on the word processing software. It gave me a word count. It says that I have less than the 13,000 maximum words. And I gave them screenshots in the whole 9 yards within my emergency motion. And then as far as the rest of it goes, I said, but if you're still going to make me do this anyway, I said, then I asked the other side and they have not objected to me having 90 days because, mind you, I was less than a full week out of my latest emergency surgery. And I was going through daily treatments at Advent Hospital. Every single day I was at the hospital from about 10 a.m. till 2 p.m. And I had oncology appointments and physical therapy appointments and surgical follow-up appointments, all of it. I was on pain medication. I said, there's just no way I can properly do this right now. So give me 90 days. And the city didn't even object. But the Court of Appeals wrote back and they said, nope, we'll give you 25 days. You still got to do it. And instead of 20 days, fine, we'll give you some extra time. We'll give you 25 days. Now, of course, at that point, that was December 5th. So did that really give me 25 days? Because we had Christmas and Christmas Eve in there. And my anniversary is December 22nd. And I still had all these daily treatments and everything else like that. So, not really did I have 25 days. But the deadline was December 30th and I filed it December 29th. I figured out a way to shorten it. I shortened it by thousands. I didn't know how much to shorten it by because it already fit in the word count requirements as far as I could tell on my end, but I did my best to shorten it and I turned it in. So then that was December 30th. Then I get on February 5th, I get another order striking my third amended petition, ordering me to do a fourth amended petition. And I want to say this time they gave me 10 days to do that. Yes, they gave me 10 days to file a fourth amended petition. And this time they actually gave me words. They said that my brief was still 17,144 words. And I was like, well, I can't get any PDF or word processing software. Even Mike at his work, he was opening it on the software they have there. We could not figure out how they got to 17,144. But at least I knew if whatever they were using to count to was 17,144 and the court rule says I can only have 13,000, I knew that they would reject my filing unless I took out 4,144 words. So at least it gave me something to go off of. So that's what I did. I kind of worked backwards in that sense. And I said, I got to figure out how to cut 4,100 words out of this brief when they violated every single court rule, law, and constitutional provision that you could possibly imagine in the course of this thing. Because we not only at that point have the city that's violating court rules and procedures and laws and constitutional provisions, but we had a magistrate and a circuit court judge who were both violating the court rules and constitutional provisions and state laws. So with that, I did shorten it. And it was due February 17th because it would have fallen on a Saturday. So I had until the next business day. February 17th was a Monday. And when did I finish it? On Valentine's Day, like 8 o'clock at night, 7 o'clock at night, something like that. I finally finish it up did my double checks and everything, triple checks, and I get it filed on the 14th, so 3 days early. And then you have a reply brief. Normally you file your brief, and then the other side files their response, and then you file a reply. And a reply is typically much shorter. Here in Florida, it's either 3,000 or 4,000 words total. But I had to wait until so they had filed their response without actually changing anything. They didn't update page reference numbers to my changes or anything like that. So anyway, I had to file my reply brief based on the version that they had submitted earlier. So it's kind of weird because my main petition was filed after then their response, and then my reply was coming after that. So anyway, I went ahead and all weekend long I worked on that, and I filed that on the 16th. So my reply brief, my last brief, was sent and filed on the 16th of February. So all of it was said and done before the 17th, the deadline for sending the initial 4th amended petition. Anyway, so again, the beginning of February, middle of February. So you have the middle of February to the middle of March. So March, April, May, and it was a little after, it was like, the end of May. So you have 3.5 months that they waited. And then what do I get? I get a 1-page order that says, and it's on the website right on there. You can see it. I put on there. They said that it was an order to show cause. I had 10 days to respond in order to show cause, to show why my case should not be dismissed because it was untimely. The petition was untimely. And I'm like, which petition are you claiming is untimely at this point? You have made me file 5 of them. So I had to go through and explain why every single one of them was timely filed, talk about the court rules, talk about everything else that was in there. And at any rate, that's where we're at. So the latest thing that you will see on there was from last week. I gave myself, the weekend and Monday to just kind of think about it. And then Tuesday, I really got to work, put it all down in writing. And so Tuesday last week, a week ago today, I filed that response. And that's the latest as far as I know. So if you want to help with that case, certainly I could use your help with some prayer. We could use prayer that we are victorious in this Court of Appeals case. And I don't just want a win for me. It's at the Court of Appeals now. If I've had to suffer for 3 years with this, going on 3 years with this, and deal with all the nonsense and how the government officials and court officials and everything have violated the court rules, the statutes, and the constitutional provisions involved, then I want a win that's going to impact and benefit the millions of other homeowners across the state of Florida. I want a win that language is going to be clear that government officials and courts cannot do this. Not just to me, but to any other homeowner. That's the kind of win I want. So if you can join me in praying for that today, I would greatly appreciate that. Another link on there, restorefreedomkh.com/resources, is basically a step back from that OB case link. And you'll be able to see other kinds of resources I have for you. I will hopefully eventually get even more up there, but there's already tons of stuff up there. There's thousands of pages of legal resources available for you to use right at your fingertips, all for free, no matter what kind of case you're going through, civil, criminal, whatever. There's a ton of different constitutional issues all talked about right there as well. So, all right, I just wanted to see you guys have had a lot of good chat going back and forth, and I didn't see any questions that were for me. I just did a quick scroll, but anyway, so I'd ask for you to be with us in that, and also we will have one more show between now and my birthday. So I'm really hoping that God's going to come through and give me the best birthday present ever. and give me that win and that victory in the Court of Appeals before my birthday. July 3rd is my birthday. And Mike's birthday, my husband, is July 7th. So we are all about freedom in this household, I'll tell you that. The 4th of July is one of our favorite holidays here. So, okay. So with that, I thank you all for joining me today and for supporting the work that we do. I will continue to do these videos twice a week, the second and fourth Tuesday of the month at noon Eastern Standard Time. And I hope you continue to join us. Give us your updates if you're someone who has called in and asked questions about your case. We'd love to hear the updates there. Speaking of updates, I just want to double check. Oh, okay. So I did get confirmation that there was a guilty plea yesterday for Lane. So let's pray for that whole situation, that that there's justice that can be found in that situation somewhere. So, all right. Thank you all for joining me. I will see you guys all 2 weeks from today. I guess that would make it June 24th at noon Eastern Standard Time. So make sure to join us then and check out all of those resources and updates in the meantime. And hopefully I'll get some other updates and things continually posted out to you as well. And I'm trying to get back into the swing of things of doing the newsletter more frequently like I had been doing. So hang in there with me as I navigate the end of the homeschool year with my daughter and the start of summer and all those other things. So yes, those people that did me dirty are psychopaths. That is for sure. All right, guys. All right. Thanks, guys. Have an absolutely wonderful day and a